my appreciation for all of you, because we have seen this like many other things in this country. This particular realm, again, has lots of opinions. People have strong opinions, strong likes, strong preferences, etc. But very little of it is evidence based or research based or data based. And therefore, when I say that I have lots of appreciation, the appreciation is because of the fact that you are filling up this lacuna. When people are speaking in the air on some WhatsApp, based on some WhatsApp forwards and all that, you are the ones who are diligently doing research, collecting data, making your studies very empirical. And I have seen the topics of the 10 presentations that are going to be made. Some are going to make it right here, some are going to do it online. So my respect for all of you, because this is something very valuable.
In the last few years, there has been a lot of interest in using emerging technologies like AI to reduce case pendency and delays in the court system. So, for example, case management softwares, intelligent scheduling are being used here. There is also a movement to use AI for improving access to legal information. So softwares for automatically translating English language judgments into vernacular languages have been piloted. But the question is that all of these technologies are built on large amounts of data. What are the stories behind this data that are foundational to these technologies? Explore this question through this essay. I'll begin with a brief history of how case data is being collected and curated in the Indian legal system. So collection of case data is a very critical part of the legal system. It's indicative of a good, well-functioning legal system because people then have access to judgments and settled principles of law. So since the late 1800s, starting in 1875, actually, the Indian law reports were released, which are paper-based case digests of all reportable judgments that have some kind of precedent value. And then you also have other case digests like the All India Reporter, Supreme Court cases, and these digests, they curate law from case law from both Supreme Court and different high courts. Then in the late 90s, the Supreme Court cases, it's a private company, introduced the first electronic database in a CD form, and this was the case law database. Then mid-2000s onwards, the e-courts project started, which then picked up pace in the digitization of case proceedings. So case data is collected at the court level in the case information software. And then this data is also reflected in the National Judicial Data Grid, which contains aggregates of court statistics and has data on court pendency, case delays, etc. And then in 2010, SEC launched the first web-based edition of Indian cases, which also enabled keyword search. So now instead of going through indices of judgments of case digests, you can actually put in a keyword of a particular provision or law or a case name, and the system immediately gives you that case. And then more recently, beginning in the early 2020s, researchers have been working on building legal language data corpus, which can then be used for natural language processing. So for instance, someone's built a Hindi legal language data corpus, which brings together data on Hindi legal texts like legal provisions, legal statutes, as well as case information. And all of this is annotated, so you can immediately find information on provisions, on statutes that are used in a particular case, on arguments by parties, etc. So what are some use cases where this data is already being used? And for the purpose of this essay, I've only focused on AI-based and ML-based, machine learning-based use cases. For instance, chatbots are being developed for legal research. An example is Jharkhand Samvad, where judges can use this almost conversational AI model to input some information. For example, they can ask for relevant facts of a case or arguments by parties, and the system will give them that information. Then you also have case summarizer and case analysis tools. So these would automatically summarize a case or analyze a case based on information or data that is annotated around parties' names, the rationale of the judgment, arguments by parties, and they will then give you that information. We also have predictive analytics where large amounts of data, case data, are being processed to identify trends and patterns in that data. For instance, data on bail cases can be processed or analyzed to understand what are factors that would influence whether a person will get bail or not. And then this data is also being used for supplemental activities by parties who have access to this data. For instance, it can be used for legal background checks to see if somebody has defaulted on a loan in the past. So because this data is accessible, freely accessible, you also have access to different kinds of information within that case data. Therefore, you do see these emerging use cases of AI and machine learning using case data as foundationals. But there are also challenges and risks associated with the use of this data. And some of these challenges and risks are well documented. You have bias from the data that can cause discrimination and lead to a denial of rights. Automation bias can emerge from this, from using AI applications, ML applications in the justice system. For the purpose of this essay, I'm not looking at individual or collective harms, but I'm looking at more system level or structural harms that the use of case data can bring. So one is around the implication of exclusions from data. Now, case data or data of judicial proceedings does not reflect ground realities or the actual truth behind data or the experience of people who are part of that particular proceeding. So for instance, your case status will say that a particular case was adjourned on a given date, but it will not say why that case was adjourned. And sometimes there are multiple reasons that inform why a certain person or a party cannot make it to a case hearing. There is research that suggests that there is only a bus there's a single bus that goes from a village to a court, and if a party misses that bus, they are not able to make it to court on that particular day. So data does not capture the actual social legal experiences of parties who are part of that proceeding. It can just the mere availability of data and its use can also lead to a kind of managerialization and quantification of justice. This is, we call it justice by numbers, where the availability of data means that it can be processed or analyzed to make some kind of inferences from that data. For instance, it can be used to say that identify a public prosecutor has gotten the maximum number of death penalties in a particular district. And in states like Madhya Pradesh, there are incentives for getting the maximum number of death penalties for a public prosecutor. So the availability of data and the reduction of court proceedings to numbers also kind of enables this kind of managerialization or quantification of justice. The third is around the stagnation of legal development. Now, as I mentioned, predictive analytics depend on large amounts of case data to identify patterns and trends in that data. But the thing is that it's the same kind of data that is analyzed and processed, right? And this risks stagnating legal principles, legal reasoning, because if, say, for example, judges and lawyers are become dependent on these tools or softwares for their final judgment, decision making, or for legal argumentation, there is no incentive to think of new legal reasons for a particular kind of case. Now, India is a common law country, judgments have precedent value, but in the past, precedents have been overturned if they were found to be bad in law. The use of softwares or tools that process or analyze this data means that then there is no incentive to think of more legal reasoning or legal principles that inform a particular kind of case. The fourth is around the commercialization of case data. Now, because this data from court proceedings is available at a level where it's accessible to a lot of individuals, it can also be used by third parties who build softwares and tools which become proprietary in nature. And they're also expensive tools. Building AI tools, machine learning tools, they're capital intensive. They need human capacity to build these tools. And because of that, they're usually expensive in nature. What this means is it can lead to a situation where only well-heeled litigants have access to some kind of tools. So, for instance, if there are judicial analytics tools that identify the trends and patterns that a particular judge has in deciding certain kinds of cases, one party could have access to the data while the other could not. So this could also lead to further inequalities in the justice system. So to avoid these challenges and risks, we need to rethink our pathways to data governance. And what I talk about in the next few minutes, they're really suggestive nature, and I'm open to feedback on these points. So records of judicial proceedings are essentially public documents. They have to be out in the open, as mentioned earlier. They're indicators of a well-functioning legal system where people have access to settled principles of law. But the availability of this data and the increasing use of artificial intelligence, machine learning, and the ability to crunch and process this data also means that there are now more use cases and instances for misuse for this data. So how to avoid falling into technology lock-ins and misuse of case data? One is to step away from treating case data as a commodity or trying to extract value from that data. These are case data they are representative of court proceedings, but the moment you start treating them as commodities or things that can be used to extract some kind of value from, there is a risk of it moving into the realm of commercial interests or for profit-oriented motives. So the first step in this is to understand that courts are only custodians of case data. They are not owners of this data. So in an ideal situation, they should not have sole say in determining what is a case, how data is collected, where it is stored, and for what purpose it will be used. So to enable that, you need consultative processes that inform data collection and use. You bring in all stakeholders, data generators, or people who are contributing to this data, who are generators of this data, people who are storing this data, managing this data, bring together different stakeholders and actors to inform decisions on how data is collected, where it is stored, how it is managed, who has access to this data, who can use this data, are there payments for this data, who gets benefits from payments for this data. The third part is to have some kind of use case-based risk assessment. So, for instance, if data is being used for profiling, you will not want case data that has personal information to be used for some kind of background check or profiling of that data. So you would want to preempt such use cases which cause harms to individuals, which can lead to exclusion or denial of rights for individuals and groups. The fourth is to have privacy safeguards for this data. Now, the data protection law does not consider judicial data as having personal information, but we all know that case data has sensitive information in it. It can have information on addresses, it can have information on sensitive information around incomes or people's properties or different kinds of information. Now, the case information system has some safeguards in place for data anonymization. So cases related to sexual abuse, key information is hidden before it's made public. But as I mentioned earlier, like data in individual and aggregate forms can also cause harm. So while information, say, on one individual who represents women in dowry cases, it's inconsequential. But in a group, this data can have different implications. It can be used to identify, say, for example, an advocate who only represents women in dowry cases. So what are the implications of using certain kinds of data in aggregate or in individual forms? And some of this data is sensitive in nature, it's personal in nature. People don't want to reveal that data, don't want it in public forums. And we've had multiple cases in the past where people have invoked the right to be forgotten to expunge records from judgment data. So we need to rethink privacy safeguards for case data as well, and think of new ways to protect people's personal information and sensitive information. And I will leave with a final thought that we need a very people and purpose-oriented governance structure for case data. And this is also to avoid a situation where we have a system where access to data ends up meaning access to justice. Thank you so much for your time.